indicates. A collective responsibility on the one hand, I think, because primarily it's for the states to implement the guarantees that are in the African Charter and other human rights instruments. The responsibility of the African human rights bodies would be to monitor, to guide states in that function of implementing the African Charter and other human rights instruments. That brings us to the part of the responsibility that lies to, let's call it, civil society and academic institutions like the Center for Human Rights. I think our responsibility is to ensure that these decisions are more broadly disseminated and better understood, because I don't think one can give that function to the bodies themselves. So I think it's in the framework of this broader responsibility, I think, that we understand an institution like the Center for Human Rights to have, that this series of case discussions take place. So the idea is that we will have decisions by the three bodies discussed from time to time. That would be the African Commission on Human People's Rights, the Court, and then the Committee on the Rights of the Child. We started off with a decision by the Court, and today we're still at the Court, but we promise that in future series of this discussion, we will definitely also look at findings of the African Commission and the African Children's Rights Committee. So I welcome you again. I welcome our esteemed panelists who will be introduced. I thank Henrietta for chairing this event, and also I thank the members of the Centre's Litigation and Implementation Unit, led by Felusho Adegalu, for bringing this event together. Welcome, and we look forward to your participation during this discussion. Thank you.
Awesome. Thank you very much, Prof, for that opening remark. Now we're going to go to the Commissioner, Honorable Commissioner Solomon Derso from the Commission, to speak to us from the Commission's angle about bringing this case to the court. Over to you, Commissioner.
A very good morning to you, all colleagues, or good afternoon from wherever you might have joined us today for this very excellent initiative. I would like to actually extend my appreciation to the Center for Human Rights for launching this initiative for a joint reflection on the judgments or decisions of the leading institutions of the African human rights system, the African courts, the Commission, and the committee. This is important also in not only pursuing, as Prof. Franz said, the motto of the African Commission on Human and People's Rights: human rights are collective responsibility, but also in understanding, in reaching our understanding of the jurisprudence of the human rights bodies of the African Union. That understanding hopefully also helping not only in popularizing the judgments and decisions among the wider African human rights system stakeholders, but also potentially creating opportunities for the follow-up and implementation of those judgments and decisions. I'm Solomon Ayele Derso. I'm an Ethiopian. I am currently a member of the African Commission on Human and People's Rights. In this capacity, among others, I am responsible as the country rapporteur of Kenya. So my entry point in speaking to you today is from the vantage point of a member of a commission who is a country rapporteur responsible for the file that was referred to the African Court on Human and People's Rights for purpose of the court deciding on the Ogiek case. I think it's good to start off with some reflections. I don't think that I will take all the time that has been assigned to me, but one of the issues I think worth reflecting on and to my mind deserves a closer investigation related to the factors that led to the decision of the African Commission to refer the case, the Ogiek case, to the African Court on Human and People's Rights. I think it's worth remembering that the Ogiek case involves a community in Kenya having a distinct culture, living in one of the major reserve areas in Kenya, who under the excuse of trying to protect a natural reserve area were evicted from a land and a forest on which they depended for a long time for their survival. And these are communities who are attached to this Mao forest for their not only livelihood and socioeconomic survival, but also for their collective existence, other community, including for purpose of their culture and religion. And they have been pursuing various efforts to get redress within the Kenyan legal system as part of a very long period of court litigation. And later on, I think around 2009, they now realized that they are not able to find the kind of resolution and redress that they were seeking with the Kenyan courts, and therefore they took a decision for taking the matter to the African Commission on Human and People's Rights. So they filed a communication with the African Commission on Human and People's Rights. And then this was also a time when I think it's worth remembering for us. The Commission was dealing with a similar case, that of the Indorois community's case. And indeed, it was around this time that the Commission handed down its decision on the Indorois case, Indorois versus Kenya, which is now one of the landmark decisions of the African Commission on Human and People's Rights. It took a bit of time for the Commission to, having regard to the context in which this communication of the Ogiek came, to reflect on and make a determination on how to proceed. So the question that I'm raising, therefore, is the extent to which the context of the receipt of the Ogiek case had affected the decision of the communication to refer this communication of the Ogiek to the African Court on Human and People's Rights. This issue is particularly important, considering that this is the first communication referred to and pursued to finality successfully from the admissibility, merit, and reparation stages. So this is, if you like, a test case as far as the question of referral of cases by the Commission to the court is concerned, and indeed a test case for having a practical understanding of the question of whether and how complementarity functions in practice, not really in theory or our thinking about based on even the experience of other systems. So, what is the context? What are the factors that informed? When I raised this question, the importance of it lies in the fact that Okay, what I am insinuating is basically the fact that it's not simply the fact that there is a provision in the rules of procedure of the African Commission, which actually establishes the basis for referral to the court that actually triggered the referral of this case to the African Court on Human and People's Rights. That, if that was enough, for referring communications or cases to the African Court, then we would have seen, that provision having been used for other cases as well. But we haven't, all right? So it's important to remember that this is a time at which the Commission handed down its decision on the Indoro's case. There are questions of non-implementation around even the Indoro's case. And of course, the Commission also at the time adopted provisional measure with respect to the Ogiek communication. Those provisional measures were not also complied with by the respondent state, Kenya. So I think it's really important to bear this in mind, when we speak about the referral of this particular case to the African Court on Human and People's Rights, because this raises questions whether or not if we, for example, would like to believe that this is a precedent in terms of referral of communications to the court, whether the precedent with respect to the Ogiek is replicable for other cases. And I'm not really sure if there is a very solid strong answer in the positive to suggest that yes, this is easily replicable for other cases, and therefore sets a precedent that can easily be followed up. Without appreciating the specificity of what propelled the Commission to refer this case, it wouldn't be possible to make sense of why this is such a first and thus far only case fully litigated before the court within the framework of the complementarity relationship between the Commission and the court. Another point that I would like to raise is also, questions in terms of, now opportunities. What are the opportunities that the referral of this case to the court brought about? What are the opportunities that might have been lost if, for example, now I'm in the really a very hypothetical realm, if this case was pursued, for example, within the framework of the African Commission on Human and People's Rights itself. So, we can raise, that question. How different would it have been in terms of the kind of judgment that have been reached at by the court and what could have been reached at by the Commission? For example, you can ask the question, as the applicant, the Commission working with the original, complainant, made a submission that the kind of treatment that was meted out against the Ogiek was of such a nature that actually threatened the very collective existence of the Ogiek, and therefore constituting violations, among others, of the right to life, and that of, for example, Article 19 on the right to existence of a people, right? One of the things that the court didn't entertain is this one. The court didn't accept the argument made in this respect, right? There could be various explanations for that. But one can't help wondering, considering, among others, for example, the fact that the Commission has a spatial mechanism dedicated to the rights of Indigenous peoples, whether the Commission, against the background of its landmark decision on the Indoro's communication, would have taken the jurisprudence to the next level by also, for example, even establishing and indeed making a finding of violations of Article 4 and Article 19 of the African Charter on Human and People's Rights. So I leave, that thought and question to you as well. This argument was not entertained by the court. I mean, just to say, potentially an opportunity lost from that perspective. Now, another point, that is worth looking at is from the African Commission's perspective. This is a test case that brought out in full the institutional, legal, and resources implication of what on the face of it appears to be an innocent provision of the protocol to the court on complementarity. When you read, the provisions on complementarity of the protocol to the court, you would say this is something that can easily be, operationalized. But when you test it in practice, as it was tested with the Ogiek, it is then that the very magnificent institutional, legal, and resource implications of the operationalization of the provisions on complementarity come to view. And indeed, it came to view in this context. And that raises fundamental questions on the extent to which adequate thinking actually went into the crafting of those provisions in terms of creating the necessary conditions to make it possible for those provisions to be operationalized meaningfully and effectively. So the institutional, legal, and resource ramifications of those provisions, came out fully in the course of the Commission litigating this case with the African Court on Human and People's Rights. It's also a case for testing some of the assumptions that underpin the referral of the case to the court. Indeed, the hypothetically crafted rules. It's also a case for testing the hypothetically crafted rules in the 2010 Rules of Procedure of the Commission, as far as referral of communications to the court is concerned. Those provisions in the Rules of Procedure were crafted hypothetically. They were not informed by any practice. That's what I mean. And this was the first time that they were tested. And the assumptions, what were the assumptions? Assumptions that you would find, for example, in the discussions, whether it is in the Commission or with the complainant, with the original complainants. The assumptions were, look, taking this matter to the court would give much more legal force to the case than litigating it with the Commission. That there is a higher prospect of implementation because it is a binding judgment as opposed to the decision of the Commission. Okay, these were some of the assumptions that underpin the referral of the communication to the court. And I ask and wonder whether or not these assumptions were borne out by actually what happened in the course of litigating, and indeed, importantly, subsequent to litigating this communication. And indeed, the question around the rules of procedure of the Commission, the 2010 Rules of Procedure. The lesson from the communication, the referral of the case, is basically perhaps, there was an assumption in the Rules of Procedure on referral of communications that says that there is hierarchy between the court and the Commission.
Commissioner, just to remind you of the time, so we're out of time, so we can just wrap up within the next minute.
Sure. So basically, asking the question whether that assumption of hierarchy between the Commission and the court actually wouldn't fly in the face of the essence of what complementarity assumes, what complementarity actually legally means. I think this is a question that I would like to pose and pass on to as well. I think there are a few points that I would like to raise, and then I would stop. What is the nature of the role of the commission when it refers a case to the court? I mean, there are a number of questions that this case brought to the fore. What is the nature of the role of the commission? Is it just a conduit for channeling cases to the court? Is it a prosecutor? Does this role constitute a completely new additional mandate or role to the commission, additional to the mandate, the core mandate of the commission as envisaged in the African Charter on Human and People's Rights? How does this change the nature of the mandate of the commission? How does it square with the core mandate of the commission? For the commission, after a decision on referral, issues that came up are, obviously assigning of a rapporteur, and then the whole question, how does the commission go about litigating this case? And does the commission, through the rapporteur, represent itself before the court, or does it actually outsource the representation to other actors? What should be the relationship between the commission and the original complainant? What is the status of the commission when it appears before the court? In pursuit of a case, the commission referred to the court under the provisions of the court protocol on complementarity. Is the commission like any other ordinary party before the court? Or is there something that is qualitatively different about the commission? How should the commission go about its role of, quote unquote, being a prosecutor, and how does that square with its promotional and indeed its protection mandate? I mean, these are, some of the questions that have been raised. Prosecuting a case before the court, in conclusion, carries enormous responsibilities. That's what we have realized. It requires extensive technical capacity, dedicated capacity in that, dedicated time, and financial resources. So the commission has to balance between being responsible for the submission of the file with the court, and indeed, it tries to balance sourcing from outside the technical and legal work for making its submissions with the court. And what are the responsibilities of the commission as far as the follow-up of this kind of cases is concerned? So I raise a lot of questions rather than giving any concrete analysis with respect to the experience of the commission in litigating this, the Ogiek case, an important case with the African court. I stop here. Thank you very much for your kind attention.
Thank you very much, Commissioner. Those were a lot of thought-provoking questions. I think the academics in here have research questions to run with. So thank you, thank you, thank you. We're going to go now to the court to hear from two of the officers from the court, the senior legal officer and the principal legal officer. So for 20 minutes, Dr. Nkhata and Dr. Teferra will be speaking to us. Over to you, Dr. Nkhata. You split the time amongst yourself. I'll just tell you when it's 20 minutes. Okay, Dr. Nkhata, please.
Thanks, Henrietta, and good afternoon and good morning to everyone from the court in Arusha. Should I switch on the video, or you're all right with this?
Yes, please, you can switch on your video.
Okay, so because the court delivered two separate judgments, one on merits alone, a standalone decision, and the other on reparations. My colleague, Dr. Teferra, will take the first 10 minutes to speak about the merits judgment. Thereafter, I will take the other 10 minutes to speak about the decision on reparations. So I'll hand over to Dr. Teferra for now. Thank you.
Okay, thank you.
Can you hear me?
Yes, we can.
Yes. All right. Thank you very much. Good afternoon, everyone. And thank you for inviting us to speak on this important matter. Is it possible that I share the PowerPoint? or just as I speak?
Yes, you can share your screen and
okay. I think let me just, I can see my PowerPoint, but unfortunately I cannot see. Let me speak from this side. Okay, so I will be speaking on the normative aspects of the court's decision in the Ogiek case. And I'll focus more on the jurisprudential contributions of this judgment. The decision of the court in the African Commission on Human and People's Rights versus Kenya is one of the landmark judgments of the court. The application had many unique features. The first one is, as Commissioner Derso pointed out, this is one of the first cases where the commission appeared as an applicant or referred a matter. The second peculiar feature of this case was that the application was filed against a state which did not deposit the declaration required under Article 34.6 of the protocol. As we all know, Article 34.6 of the protocol requires that for individuals and civil societies to access the court, the respondent state against which a case is filed before the court must have deposited that declaration, special declaration allowing individuals and civil societies to have direct access to the court. So this was one of the first cases where a case was filed against a state which did not deposit that declaration. And as we know, the respondent state is the Republic of Kenya. The third peculiarity of this application is that the application contained several issues that the court dealt with for the first time. For example, the definition of indigenous people, who peoples are in the African Charter, the right to self-determination, the right to culture, and so on. So it was the first opportunity for the court to address or to express its views and make pronouncements on these important rights. When it comes to the jurisprudential contributions, I would like to focus on three main areas. The first one is access to the court and complementarity. The second one is with respect to the admissibility of applications before the court. And the third one is on merits. And my colleague, Dr. Mwiza, will come later to explain the normative contributions of this judgment on reparations. To begin with access to the court, as Commissioner Derso pointed out, this case was filed before the court by the commission. As we know, under Article 5.3 of the protocol, the individuals and civil societies can access the court on the condition that the respondent state has deposited the declaration, which I mentioned earlier. Since Kenya did not deposit the declaration, the commission brought the application on the basis of Article 5.1a of the protocol, which gives which provides the commission as one of the entities which are allowed to have direct access before the court. So the commission filed on the basis of this provision. This enabled the original complainants or the original applicants before the commission to circumvent the requirement of declaration prescribed under Article 34.6 of the protocol. The court's decision in this regard, the court's decision to dismiss the objection of the respondent state that it didn't give direct access to individuals and the original complainants did not have a standing before the court. The court's decision to dismiss this objection in a way in a way, promoted accessibility before the court for individuals and civil societies, which could haven't been possible if the court sustained the objection of or upheld the objection of the respondent state. More importantly, again, I have to quote Honorable Commissioner Derso, this was one of the practical tests of the complementarity relationship that is envisaged under Article 2 of the protocol. The protocol says that the court is established to support the protective mandate of to complement the protective mandate of the commission. And it remained a kind of a theoretical issue until this case was filed before the court. Note that this is not the first case. Of course, the commission referred at least 3 cases before the court, but the real test came when this application was filed. So this application or the judgment, we could say that it reaffirmed the complementarity relationship between the court and the commission. Of course, the judgment or the application presented some challenges for the court, because the court is there to complement the commission, but then the commission was the applicant or the one who brought the application before the court. And as we know, the court used to or has been referring to the jurisprudence of the commission, which was now appearing as an applicant before it. So there were some practical challenges in that regard. But nevertheless, overall, we can say that the Ogiek judgment reaffirmed or reinforced the complementarity relationship between the commission and the court. When it comes to admissibility or the admissibility of the application, there were 2 main issues which were raised or 2 objections which were raised by the respondent state. One was regarding the identity of the applicant, and the second one was related to the exhaustion of local remedies. On the identity of the applicant, the court interestingly held that the commission was a legal entity recognized as the applicant and entitled to bring the application. So in a way, the court rejected the objection, dismissed the objection of the respondent state, which alleged that the commission was not the applicant, but the original complainant before the commission. So I think it was an important interpretation of who the applicant is, and in the future as well, for individuals who want to access the court through the commission, the fact that the commission is considered as the applicant will help them again circumvent the prohibition or the restriction put in place by Article 34.6 of the protocol. I would like to note that the court did not treat the commission as an ordinary applicant. It was a kind of sui generis applicant, I would say. The court treated the commission as a sui generis applicant, and this is reflected on the second objection, or when the court dealt with the second objection, that is the requirement of exhaustion of local remedies. The respondent state alleged that the applicant, which is the commission, did not exhaust local remedies, and the court again very interestingly said, for purpose of examining the rule of exhaustion of local remedies, the one which brings the application before the court does not need to exhaust local remedies, as long as the respondent state had an opportunity to deal with the issue raised by the applicant in another case filed by or in a case filed by other applicants. So it was an interesting jurisprudential development, because as we all understand, the requirement of exhaustion of local remedies demands that individuals or any applicant filing a case before the court must have exhausted local remedies in principle before filing that case or bringing the case before the court. So the court in this case said it's not necessary that the applicant filing the application must himself or herself filed the application at the domestic level. As long as other applicants, other individuals have exhausted local remedies, then it's okay. We can assume or we can deem the application as having been filed after exhaustion of local remedies. On the merits section, the first area where the court expanded, let me say maybe the norms of the charter is in relation to the definition of indigenous people. First, the court considered that the concept of indigenous population is not defined in the charter, and also noted that there is no universally accepted definition of indigenous population. And then the court drew inspiration from the work of the African Commission through its working group on indigenous population, and from the work of the United Nations, a nation's special rapporteur on minorities. And then it fleshed out some relevant factors to identify who indigenous population are. This includes the presence of priority in time, voluntary perpetuation of cultural distinctiveness, self-identification, as well as recognition by other groups, and an experience of or a history of subjugation, marginalization, and dispossession. And the court held that these requirements were fulfilled with respect to the Ogiek community, who lived for centuries, since time immemorial, in the Mau forest.
I'm sorry, yes, Doctor, you've used 12 minutes so far. Just to remember, you have Dr. Nkhata coming after you. Okay, thank you.
All right, let me just focus more. Okay, let me go to the, I think, to the right to property and the right to culture, because these are the two areas where the court truly contributed to the existing human rights jurisprudence. When it came to the right to property, the court noted that the right to property in the charter is stipulated in the section where the charter deals with individual rights, but the court held that the right to property could be applicable to individual right, like individuals as well as groups. So it noted that it could be a collective or an individual right, and accordingly, it held that the Ogiek had the right to property, particularly the right to communal land, which was very important for and which is still very important for minorities who have been evicted and dispossessed by dominant groups or under the pretext of development, socio-economic development. When it comes to the right to culture, the court noted that the right to culture has two dimensions. It could be individual as well as collective, like the right to property. And the court then engaged in a kind of socio-legal analysis and observed that culture should be construed or interpreted in its widest sense, encompassing the total way of life of a particular group, including group language, symbols such as dressing codes, and the manner the group constructs shelters, engages in economic activities, and so on. The most interesting aspect of the right to culture, or the most interesting part of the court's decision on the right to culture, is its response to the respondent's objection, which was that the Ogiek community had evolved and transformed to a modern way of life, or adopted a modern way of life. This was the objection by the respondent state. And the court said that stagnation or the existence of a static way of life is not a defining element of culture or cultural distinctiveness. It is natural that some aspects of indigenous populations' culture, such as a certain way of dressing or group symbols, could change over time. Yet, the court said, the values, mostly the invisible traditional values, embedded in their self-identification and shared mentality often remains unchanged. So it was very interesting because the court looked into not only just the features that we see that are observable by our eyes, but also the invisible elements of culture. And I believe that it was a very good contribution. The last point was the definition of people. As we know, it's not defined in the charter, but the court indicated that the notion of peoples in the charter could be applicable to both individuals, both people as a nation, as well as ethnic groups, which constitute a state. So it clarified what used to be a vague notion in the charter. Finally, well, maybe just one point on the right to life. The court somehow, unfortunately, took a very narrow, adopted a very narrow interpretation and held that the right to life is very restricted to almost like a loss of life, even if the conditions for distant survival are missing. It doesn't mean that there is a violation of the right to life. I think Commissioner Derso also indicated that point. It was unfortunate, but overall, we can say that the Ogiek judgment will remain one of the most important decisions of the court. It not only offers the opportunity to clarify and expand certain norms in the charter, but also sets the foundation for future collaborative institutional relationship with the Commission. I thank you, and sorry for taking the time.
Thank you very much, Dr. Teferra. So Dr. Mwiza, your colleague has left you with just 3 minutes. I'm not sure how you're going to manage your 3 minutes. Let's say within the next 8 minutes, if you can keep your presentation short. So over to you, Dr. Mwiza Nkhata.
Thank you, Henrietta. It was already an impossible task at 10 minutes to go through what the court established in the reparations decision in the Ogiek case. I'm not sure what I'll be able to achieve in the 8 minutes that you've given me, but I'll try. So the genesis, I think the best way to understand this is to start from Article 27 of the protocol establishing the court, because under Article 27, the court, if it finds that there has been a violation of a human or people's rights, can make appropriate orders to remedy the violation, including the payment of fair compensation or reparation. Key there is that the court is mandated to make appropriate orders to remedy the violation, and that fair compensation or reparation are simply highlighted as some of the things that the court could order. So the scope, the normative scope of what the court can do to achieve reparation is very, very wide under the protocol. The judgment on reparations is a very wide-ranging judgment, and it comprehensively deals with reparations in the African human rights system. And in the time that I have, I think I will not be able to adequately canvass all the issues. However, to properly understand some of the unique contributions that the court made in this decision, I think we have to look at the specific findings on the specific issues that came before the court. And my plan was to firstly look at some of the procedural findings that the court made at the reparation stage, and then look at the substantive findings. I think on the procedural perspective, even at the reparation stage, the respondent state was raising objections. So for example, they objected to the fact that whatever order of reparation the court was going to make, it should not take into account events that had happened before 1992. This is because the respondent in this case, Kenya, had only become a party to the charter, the African Charter, in 1992. So it was the argument that whatever order the court was going to make should not take into account events before 1992, and also not to take into account any events that occurred around the time when the eviction notice from the Mau Forest were issued, which was 2009. However, the court dismissed that objection and held that if comprehensive reparations were to be awarded to the applicants in this case, it was important to look at events even beyond 1992, as long as this would be related to the infringement that the Ogiek people were alleging they had suffered in their claim before the court. So there is a rather permissive and flexible view adopted by the court in terms of the temporal scope of the liability of the respondent state in terms of computing reparations. The other issue that came up procedurally was the question of an amicable settlement. Article 9 of the protocol establishing the court allows the court to facilitate negotiated settlements between the parties. But in the practice of the court so far, this is not an avenue that has been resorted to with regularity. In this case, the respondent was suggesting to the court that this matter should be resolved amicably as between the parties. If you look at the judgment, the court recalls how even at the merit stage, it had attempted to facilitate an amicable settlement which had collapsed because the parties could not agree as to the issues which should be allowed to go for the amicable settlement. In the end, in dismissing the proposal by the respondent for an amicable settlement, the court basically clarifies that an amicable settlement can only be proceeded with if both parties are willing. So in a way, the court here was also charting new territory in terms of the procedure for an amicable settlement. I think in terms of the procedural issues, I'll leave it at that because I think I need to quickly move on to some of the substantive issues that the court dealt with. If you look at the substantive findings on reparations and look at the court's approach, the first thing that you will note is that the court's approach to the question of reparations generally accords with the approach adopted by other courts and other tribunals in international law in relation to reparations. So the right to reparation for a breach of human rights obligations, the court has constantly reiterated, is a principle of international law, meaning that a state should always be responsible for international wrongs and to repair the damage that has caused. If you look at the Ogiek decision on reparations and other cases decided by the court, you notice that the court has liberally referenced decisions of the Permanent Court of International Justice, its own case law, and even other international tribunals to support this proposition. The court in its practice assesses reparations under two main heads. Firstly, the pecuniary reparations, which includes material prejudice and non-material prejudice, and then non-pecuniary reparations. In this particular case, insofar as the pecuniary reparations were concerned, the applicants had requested the court to award them compensation for the material harm and the moral harm that they had suffered, particularly due to the violation of their right to development and the loss of their property and natural resources. Here, let me point out that evidentially, the applicants, through the commission, submitted a community survey report, which was meant to substantiate the claims in relation to the sums of money that they were asking for. Because this was a claim for material loss, the court insisted, and in its jurisprudence it is consistent, that material loss must be specifically proved. However, as an exception to that, the court also acknowledged that sometimes victims of human rights violations can face challenges in collecting evidence to support their claims for various reasons. So in this case, even though there was a survey report that was submitted, the court, after assessing the challenges some of which were considered by the applicants themselves, decided that it would not be bound by the community survey report that was submitted by the applicant. Nevertheless, the court considered that there was incontrovertible proof that the respondent state had occasioned human rights violations on the Ogiek people. In the main, the court therefore made an award in equity for material prejudice. The court awarded 57,850,000 Kenya shillings to the Ogiek for material loss. There was an additional question there, whether the award should be in United States dollars as the applicants had requested, or whether it should be in Kenya shillings. If you're familiar with the jurisprudence of the court, the emerging position by the court here is that an applicant will always get reparations in the currency of the country in which he or she is resident, where the violations occurred. So in this case, the court made these awards, the award in Kenya shillings. Insofar as moral prejudice is concerned, this related to violations of the right to non-discrimination, right to religion, right to culture, and right to development. And here the court acknowledges that its award must cover the suffering and the distress caused to the direct victims and to the indirect victims of the violations, and for the impairment that occurred to values that are very significant to the complainant. Here, let me just quickly say that the court also made an award in equity, and this award was of 100 million Kenya shillings. Insofar as the non-pecuniary reparations are concerned, there were several heads of reparations that the applicants claimed. One of the most important is that there was a request for restitution of Ogiek ancestral lands in the Mau. And this was premised on the finding by the court of a violation of Article 14 of the Charter, the right to property. So here, the court observes that in the context of Indigenous people's claims to land, demarcation and delineation of actual boundaries and locations of the land is necessary. Because if you give Indigenous people mere abstract or legal recognition of their lands or territories or resources, this is meaningless in practical terms until you actually delineate physically the land and mark it out to remove all sorts of uncertainty on the part of the concerned Indigenous peoples. So although the respondent had argued that the Ogiek should still just be granted access to the Mau, the court said no to that and said that there should be legal certainty with regard to the ownership of the land. Most importantly, though, you will note that the court acknowledges that given the unique situation and way of life of Indigenous people, it's important to conceptualize and understand the distinctive dimensions to which their right to property can take. So, for example, ownership of land for Indigenous people is not the same as the possession of a fee simple title that most countries recognize as proof of ownership of land. Eventually, after analyzing the parties' argument, the court ordered the respondent to undertake an exercise of delimitation, demarcation, and titling in order to protect the Ogiek's right to property, which in this case involved their use, occupation, and enjoyment of the Mau forest complex. And the court also emphasizes the importance of consultation with the Ogiek as the respondent attempts to fulfill this order. I suppose, Henrietta, that is a sign that I'm running out of time. So let me quickly wrap up. In terms of recognition of the Ogiek as an Indigenous people, the court reiterated its findings at the merit stage and confirmed that the respondent was under a responsibility, a duty to officially recognize the Ogiek, which includes recognizing their language and culture and religious practices as part of the Kenyan people. There was a request for a public apology. The court dismissed that request. The court held that a judgment can constitute sufficient form of reparations. And given the totality of the other orders that were being made in this case, it felt that it was not necessary to order the respondent state to issue a public apology. There was also a request for the erection of a public monument. Again, the court dismissed this because, again, it held that the judgment itself was sufficient reparation. On guarantees of non-repetition, the court ordered that the respondent state should guarantee the non-repetition of the violations that had been suffered by the Ogiek. So overall, I would say there are three quick takeaways that we can see from this judgment. When the court made these orders about the sums of money, substantial sums of money that have to be paid to the applicant, the court also ordered that there should be the creation of a community development fund, which was a first in the jurisprudence of the court. So these funds are supposed to be deposited in this community development fund to be utilized for the needs of the Ogiek within the Mau. And a committee of sorts has to be set up to manage these funds. Again, another important development here is that if you look at the operative paragraph of the judgment, the court is envisaging that there will be a compliance hearing. In its operative part, the respondent has been directed to report on implementation within 12 months, and thereafter the court will hold another hearing to follow up on how its orders have been implemented. And also on delimitation, demarcation, and delineation, I think the court was charting new territory here to clearly order that what is needed to secure the rights of Indigenous peoples, especially the rights under Article 14, is not simply access to the property, but a legal certainty, a form of legal certainty which recognizes the unique aspects of Indigenous tenure systems. I think in a rush, that is what I would say the court has said about the claims that the Ogiek brought to it. Thank you.
Thank you very much, Dr. Mwiza, for that very detailed presentation, given the limited time you had. Thank you to you and Dr. Teferra for speaking to us from the court's perspective on the merits and the entire process of the case. Happy to hear about the developments in concerning the upcoming compliance hearing. That's a good update to hear, looking at how the court wants to boost implementation. So now we're going to move to hear from CEMIRIDE, which was one of the organizations that took the cases before, that took this case rather, before the commission, before it went from the commission to the court. To speak to us would be the Chief Executive Officer, Mr. Ohenjo. I hope I'm pronouncing the name right. But just before he comes on, I just wanted to remind everyone that the webinar is recorded. We'll be taking screenshots as presentations are being made. And also, please feel free to leave your comments and questions in the chat box. So when we get to the question and answer session, we'll just read from the chat box. Okay, over to you, Mr. Ohenjo. Please, you have the floor for 12 minutes. When my video comes up, you know it's time up. Thank you. You are on mute.
Sorry. Am I audible?
Yes, you can proceed.
Okay, yeah, thanks, Henrietta, and thanks for the Center for Human Rights for inviting us to be part of this conversation. As it's already been indicated, my name is Nyangori, and I work for the Center for Minority Rights Development. Now, we've already listened to quite a number of speakers about this case, the reparations case, the case that was whose judgment was delivered recently. So I'll not go so much into repeating what has already been said, save for the fact that this is really precedent setting when it comes to jurisprudence revolving around Indigenous peoples and their rights in Africa. Now, very briefly, just about CEMIRIDE, as has been mentioned, CEMIRIDE, together with Minority Rights Group, first took this case to the African Commission in 2009. CEMIRIDE was established in 2001. It's been in existence since then, and it focuses on working with minorities and indigenous peoples in Africa to secure their rights. So our mandate is purely around issues of ensuring promotion and protection of minorities and indigenous peoples. Now, the most defining aspect of existence of CEMIRIDE is that by the time it was being established, the recognition of minorities, indigenous peoples, and in this particular case, indigenous peoples, was not yet really properly documented within the African context, let alone Kenya. So we were chatting in new waters in trying to ensure that this recognition is achieved. And for us to be able to move that direction, because we were dealing with a context that was so different from the Aboriginal context. When you look at the development of the indigenous people's rights movement, it started, from the Aboriginal context. So in Africa, we were dealing with a very different situation, and therefore, to guide our engagements, we came up with an understanding of how we wanted to get, to get that recognition of the communities that were pushing for to be recognized as indigenous peoples. And we settled on a description that kind of focused more on the livelihoods and culture of the communities rather than the aboriginality. So we looked at communities that had retained and maintained a traditional lifestyle and livelihood, that is pastoralism, forest dwellers, where the Ogiek fall, and fishing livelihoods. These communities were basically then natural resource dependent, and therefore their lives, culture, religion, everything revolved around natural resources. And that is how we then settled on making a decision that this is how we want to describe or define indigenous peoples, not only in Kenya but in Africa. And that is that conversation is what has led in a very significant way to the jurisprudence around the definition aspects. Now, in Kenya today, 20% of the Kenyan population, according to our very recent census, is indigenous peoples, because we've been able to push for, ethnic identification of certain communities, not all of them. And now we've been able to disaggregate and come to the realization that actually 20% of our population is indigenous peoples. Kenya recognizes the rights of indigenous peoples through its current constitution that was enacted in 2010, articles 56, 100, and 260, which provide, 260 provides for the definition, and Chapter 11 on devolution provides for participation in governance. What is very critical is Article 2 of our Constitution provides that any treaty that Kenya is party to is part of the Kenyan law. And that means that decisions that are entered by the African and ended by the African court and accepted by the Kenyan government then automatically become part of the Kenyan law and should be implemented as part of the Kenyan law. And that is part of the jurisprudence that is developing. What we note going forward is that Kenya has, in the recent past, been a little bit more progressive in recognizing indigenous people's existence in Kenya. This was resisted initially, and that is why in the constitution we ended up with marginalized communities, but this has been changing. So I'll not go into really the facts and understanding of the Ogiek community. I think most of us have read through the documents. The Ogieks number about 30,000 today. They are forest dwellers, as we've already had. Their livelihoods revolved around the forest areas, including Mau. The Ogiek in Mau is just one group of the Ogieks. There are a number of other groups of Ogieks around Mount Elgon that are also, part of the community. They may not have been part of the case, but they are also known, and they identify themselves as Ogiek. There are others around the Eburu forest, which is a little bit away from the main Mau forest. The main characteristic of the Ogiek is that, yes, they've lost a lot of their physical, cultural traits, but they retain that identity. This has been because for years, before and after independence, they've been subject to arbitrary evictions and forced assimilation policies over the years that started with the colonial government. And this prompted our conversations and decision to then go to the African Commission, which case was then taken to the African Court by the African Commission. So I do not want to go into the facts of the case and the decision that the African Court made in 2017, because we were told to focus on more on the reparations. However, critical is to look at what orders had been given in 2017 in the 2017 judgment, because then that dovetails us into the reparations. One of the orders was that Kenya was the Kenyan state was told to take appropriate measures within a reasonable time frame to remedy all the violations and inform the court of the measures. The other one was the Ogiek were then supposed to file their reparations, which is subject to this conversation, and the government to respond thereof. Kenya, pursuant to that particular judgment, Kenya actually formed a task force, and during the reparations, there was that argument that Kenya had formed a task force, so the reparations case should be stood in view or in lieu of the task force work. However, it's important to note that this task force, which was to study the judgment and any other related local judgments, as well as all relevant laws and policies, and recommend redress, did its work, but has never made, its report has never been made public. And most important also is that the Ogiek and other indigenous peoples were never consulted in the formation of the task force, which of course brings in the whole question of FPIC as elaborated in the judgment, that is free prior informed consent. The task force was also supposed to conduct public awareness on indigenous people's rights. This was not done. So as I said, the report is yet to be released, so we're yet to know what kind of recommendations the government or the task force provided. Now, after that, after the whole task force episode, of course, then we had the reparations judgment, which was delivered this year in June, just a few months ago. And key, as has already been mentioned, were the pecuniary compensation orders of 57 million for material prejudice and 100 million for moral prejudice. But then significantly, the court also ordered that the government put in place legislative measures and in consultation with the Ogiek, of course, to demarcate the land, from communal title, and also take appropriate measures within 1 year to guarantee the full recognition of Ogiek as indigenous peoples. Okay, I would say that the government in its policies nowadays recognize indigenous peoples. So that is something that is on paper. And of course, the setting up of the Community Development Fund, which are very interesting proposals. In terms of contribution to jurisprudence, and I think this is something that is what we are looking at today, is that the Ogiek case, the reparations, and the main case, the merit decisions, and the Endoro's case, and there are several other cases that the Commission has handled around this particular context of indigenous peoples and ethnic communities in Africa, I think provide something that, in terms of our work is critical. The recognition, the affirmation of recognition of the rights of IPs to traditionally own their lands, because this is something that it's something that is actually moving away from how governments have operated when it comes to collective and individual ownership rights to property. And we are starting to recognize communal or collective rights, which is very important, especially where community rights are involved with regard to indigenous communities. So it's a new area of engagement. It's something that is it's knowledge that is just emerging. The communities in Africa can actually pursue collective rights. And this is not just the Ogiek, it opens up the space for other communities that feel like their collective rights to economy, socio, economic, and political collective rights have been violated. So this is space that it's an opportunity that gives us a platform on which to develop and set trends in securing better livelihoods for our people. It has also established that under the African Charter, indigenous people's rights can and are violated by the states, and therefore indigenous peoples as a collective can then pursue redress, either locally, where that is possible, or at the regional or continental frameworks. There's an established clear procedure through which indigenous peoples can pursue redress. This, as we've heard, this was being tested during this case, and it's come out clearly that here it's very possible for indigenous peoples who have claims to seek redress through the African mechanisms. There's a clear identification of who indigenous peoples in Africa and specifically in Kenya are, and identification of indigenous peoples' rights within the African context, because this was in contestation for a very long time, where there was always an argument that all Africans are indigenous to Africa, so there isn't a community that is more indigenous than the other, and things like that. We've looked at this from a progressive perspective, starting from the working group on indigenous peoples, and this is now been embedded in legal interpretation by the African court. And this therefore has provided a pathway for public interest litigation for indigenous people's rights going forward. What are some of the challenges? Some of the challenges that we look at, and this stems all the way from the Endoro's decision with the African Commission to this,
Mr. Wengo, apologies. So I've just been instructed by the moderator to tell you that you should try to wrap up. I see you are wrapping up. Please, can you do that in 1-2 minutes? Thank you.
Yeah, I'm wrapping up. I'm just looking at the challenges and then probably opportunities for partnerships. There's a huge reluctance by the government, especially government of Kenya, to implement these and other decisions. There's foot dragging around the decision making. If you look at the timelines that are always set, they're never met. There's lack of consultation of IPs in some of the supposed implementations or some of the efforts, little as they may be, by government. So certain aspects of principles and rights of inclusion and participation are not being made. One of the other challenges is capacity by communities to effectively lobby and monitor the implementation of the decisions, and lack of a proper government focal point for implementation of some of these decisions. There's need for a proper government focal point going forward. And one other very big area of challenge, especially where issues of communal title are being talked about, is the whole challenge of settlements of other people from other communities in the areas under claim. So that's a very big challenge that going forward might need to be looked into and addressed in a way that it doesn't, again, throw up animosities and conflicts. What are some of the strategies and partnerships for advocacy and effective implementation? There's need for continued African Commission and African Court activities to engage in more dialogue between the indigenous peoples in Africa and the states and other civil societies on these decisions and other relevant jurisprudential issues to ensure that everybody is on the same page, to kind of bring out the fact that it's for everyone's benefit that these decisions are implemented for both communities and governments. Capacity building for communities on how to engage with such processes is needed. Capacities in all its entirety. Communities still don't have the capacity to take advantage of some of these decisions that are very setting the trend, that are very significant. There's need for CSOs and community organizations to organize better, pull together to be able to ensure that governments live up to their commitments, especially when it comes to the African Charter. The Kenyan government is committed to the African Charter. It's already a signatory to the Charter, so it's bound by it and should be able to implement decisions and resolutions that are as a result of the Charter. And discussions such as this panel should actually be intensified so that they provide a forum for better knowledge about these issues, especially by governments. It's interesting that we do not have, I don't know if we have government, Kenyan government, for instance, officers on this forum, but it's important that there are roundtables, there are forums where some of these decisions and actions can be discussed in a way that can spur implementation. That would be one of the most effective advocacy strategy, where stakeholders can be brought together, including government and the communities involved, for purposes of just seeking a common way forward for implementation in such decisions as huge as they are. I'll stop there for the because of the time limits, and I'll be around for any question that will be thrown my way. Thank you.
Thank you very much for that presentation. Thank you. Sorry, my network kicked me off for a few minutes there. So now we're going to hear from Advocate Tom Nyaduga, who was a former member of the African Commission on Human and People's Rights and was a representative of the Commission at the courts in this Ogiek case. Advocate Nyaduga, you have the floor for 12 minutes. I'll come online again or put on my video once it's time up for you to know it's time. You have the floor, sir.
Thank you very much, Henrietta. Thank you very much, colleagues on the panel, and all those who have joined us from across Africa and beyond. I'm very happy to be involved in this panel and to discuss issues around the Ogiek two decisions, the merit decision and the reparation decision. Before I go into what I was going to say, I first of all wanted to pay tribute to CEMIRIDE, MRG International, and the OPDP for the work that they did regarding the institution of this, their original complaint to the commission, which subsequently ended up at the court. And this is very important to mention because, as Nyanguri has just said, you will all realize that from about the year 2003, when the working group report at the African Commission on Indigenous Issues was adopted, the advent of the Ndoroy's case, which was decided upon in 2009, and then the Ogiek case, the two decisions, the decisions, the two cases really put a judicial interpretation to what had already been stated in terms of the conditions, in terms of the definition, self-identification of indigenous peoples, the plight which they face in terms of the violation relating to their rights to their land. So the decision, as has already been mentioned by the colleagues who spoke before me, in terms of the significance of the Ogiek decision and the Ndoroy decision before that, cannot be underestimated. So I wanted to highlight that point at the very beginning. Now, in terms of the decision, I also want to join Commissioner Daso in emphasizing the role of complementarity in this decision, as he did stated that it was a practical, the court assumption of jurisdiction over this application was a practical expression of the complementarity provisions in the protocol. I know Commissioner Daso did pose at some point a number of questions which we need to look at, which ourselves or even scholars, we need to look at the relationship between the commission and the court. But for me, it is very significant that this case took place at the commission because it shows how possible it is for victims in states that have not deposited the Article 34, Paragraph 6 declaration can eventually get their complaints or cases heard by the court when the complementarity system works properly between the commission and the court. It's also significant that until this time, after that decision, we don't have that many other cases coming through the same route. But I think maybe some of the challenges include what Commissioner Daso mentioned, perceptions around hierarchy. For me, I would look at Article 5, Sub-Article 1, which provides the basis upon which the commission is one of the parties that can access the court. So the questions whether the commission is acting as a conduit, as a prosecutor, the fact that as indeed Commissioner Daso explained the context within which it was deemed important for the commission to refer the case to the court, I think it's very paramount because as it has been seen, the pronouncements which similarly could be seen in similar terms as those which the commission did in the Ndoroys provide further emphasis, particularly based on the fact that the protocol provides for the decisions of the court being binding, whereas we know that the decisions of the commission are mere recommendations. So I think the important thing is now, how does the commission follow up in terms of ensuring that this decision is implemented in as far as it was a party before the court. But I also wanted to commend the commission in the manner in which, particularly when it comes now to the Ogiek, where I was one of the legal counsels, that there was a very close working relationship, which I think is very important to underscore, between the commissioner rapporteur. During the merit stage, we worked with the Commissioner Manera Kiza, and during the reparation stage, we worked with the Commissioner Daso. That it was a team, very close, neat team that involved as I said, the commissioners, the legal counsel, the original parties, MRJ International, as well as OPDP and the CEMIRIDE, and also to commend the expert opinion that we received from expert Dr. Liz Alden, which was very important for the court to understand the nature of the livelihood that Indigenous peoples live and how they become affected when they're dislocated from their ancestral land. So it was very important. And another point which is very important also to take into account was that while we know the court can proceed on the basis of submissions, but it was very significant that we were able to bring the Ogiek people themselves, the victims, before the court. And it took a lot of effort on the part of the original complainants to bring them across to Ethiopia, because during the hearing of the merit stage, while we know the court is based in Arusha, the case at that time the hearing of the case took place in Ethiopia. So the original complainants took an effort to fly in about 50 Ogiek, and these were some of the victims who, as we demonstrated, besides being evicted, they had been homeless for a number of years. So it was very important that the witnesses appeared before the court. So I thought those were very important. That was very important information to show the process about how the court went through in determining the merit stage. Much has been said about the decision at the merit stage. I would not want to go into it, to repeat again with many of the points having been clarified. But I wanted to mention 2 points. The first one is on the amicable settlement, which I think Dr. Nkhata mentioned. And it's significant because the respondent states raised objection to amicable. No, the respondent state actually had wanted amicable settlement, but at the same time, it put obstacles in the way of a process of amicable settlement. I know Dr. Nkhata mentioned one reason, but I want to emphasize another point which has not come out during this discussion, that the respondent state was objecting to the participation of the original complainants legally, because the concept is not known within the process of litigation before the African court. But secondly, they were even pointing to the fact that they were challenging who were the genuine representatives of the Ogiek people in the case. The government, even during the reparation stage, has been referring to the Ogiek Development Association organization. And this was an organization which was set up during one of the commissions during the time of the Mwai Kibaki, Raila Odinga regime. But even that time, that the composition of that Ogiek council, the Ogiek Elders Council, was not even accepted or recognized by the Ogiek who had brought this case as representing the Ogiek themselves. And you find when it comes to the reparation judgment, where the court states that around the establishment of the Community Development Fund, the respondent state will be required to consult the Ogiek, and you wonder which composition is going to be recognized. Because if the state had consistently rejected the original complainants, particularly in the context of the Ogiek representatives, the OPDP, then it means that within the 1-year framework that has been given for the implementation of this part of the decision in reparation, then the committee might not be established because of the reluctance on the part of the government to accept those representatives, even though it's also significant to also state that the decision has said that it is the Ogiek community is free to establish any networks at the national, regional, and international level. So, which means if the respondent state was to remove its objection, then the committee and the consultation of the committee, which will be formed in the context of the Community Development Fund, will find its existence and therefore be able to implement the decision. That was one point. Now the other one, which is also important and linked to the point I've just mentioned, was the recognition of the principle of free prior informed consent. That for the Ogiek, for any indigenous peoples group, there is a requirement for consultations, and it's important that for any decision that affects them, the principle of free informed prior consent be applied when a respondent state is involved in issues around indigenous peoples. Now, when it comes to the reparation, there's one point of concern which I found in the reparation decision. It's right that the court recognized the need to delimit, demarcate and title the Ogiek property or the Mao forest in order to protect Ogiek rights to property. But then there is also the question of the private concessions, the private parties who have acquired interest in the Ogiek. And this was one of the major issues around the eviction of the Ogiek. Now, when you look at paragraph, I think it's between 115 and 116 of the decision, you will see that where it's not possible to offer land, because the court recognized that as opposed to the argument of the respondent state that they had access, they could access and use the Mao. But as a doctor, I think it was Dr. Teferra who mentioned that it was very important, or it was Dr. Nkhata who mentioned that it was very important to provide the physical ownership rather than theoretical. When it comes to the issue of negotiations between the concession holders or private interests which are already in the Ogiek, the decision says, and here I quote at paragraph 116, that it must, that is those who are already in occupation, must negotiate with the Ogiek responsible to offer adequate compensation or identify alternative lands of equal extension and quality to be given to the Ogiek for use and occupation within 2 years. Now, my question is this. We know, and this was very clearly demonstrated during the merit stage by Dr. Liz Alden, about the nature of the Mao forest, which was naturally occupied by the Ogiek. And even through expert analysis, it was shown that even though there are areas that have been occupied, the Ogiek could be given areas which would really fit with their lifestyle. And this doesn't seem to have really been given consideration. And therefore, when it comes to getting alternative land, which is out of the Ogiek, out of the Mao forest, then the challenge comes when you look at the configuration of land in Kenya. And there's a lot of pressure, in particular in some of these mountain areas. One wonders where the government will allocate the Ogiek with this land, with the land that is an alternative land that is equal in extension and the quality to be given to them for use and occupation. So I thought this was an area which has been left without much clarity, and therefore it might continue to be a bone of contention between the Ogiek and the respondent state. I'm looking at. I looked at the orders that were made, and the time frame that has been made is mostly 1 year. And the court still retains, has said that it has given an order that it will convene another hearing to assess implementation. Now, the two challenges that I see with this are, one, I have mentioned it earlier, in the absence of a structure for amicable negotiation, like in the context of the establishment of the committee to deal with the Community Development Fund. Since we have seen the reluctance on the part of the respondent state to deal with the representatives of the Ogiek who were responsible for bringing this case, and they're looking at other representatives, I find it very difficult in foreseeing a successful implementation of this process within the coming 1 year. That's one. So maybe to conclude, because most of the issues that I would have spoken to have been covered by my colleagues, but I wanted to put a question probably to Mr. Nyangori, that the decision, the reparation decision was adopted on the 23rd of June, 2022. We are in September, so a good part of about 2.5 months have gone. Are there any processes that we can learn from within Kenya about any process that lead towards the implementation of this decision? And unfortunately, the decision may be unfortunate on the part of the Ogiek and the decision. It has come at a time when there was politicking, elections in Kenya. The new government will take time before it's in place. what are the prospects of this decision being implemented within the timeframes that has been set up by the court? So I thought that these are some of the issues that I would bring out, but again, many of the issues have been raised by my colleagues. Just to finally conclude, as indeed was stated by others, that the Ogiek decision is one of those landmark decisions that I hope will inform discourse around the rights of indigenous peoples, not only in Kenya, and fortunately in Kenya, the new constitutional dispensation recognizes indigenous people, but it forms a very good source of jurisprudence for other African states that do not still recognize the right of indigenous people. So I think I will end at this point and wait to hear other colleagues contributing on this here. Thank you very much.
Hi, I did not get the first part of your question, please.
Excuse me, Doctor?
I didn't get the first part of your question. You posed a question to me about the reparation decision.
No. Well, I was referring to the CDF. I think I referred to you. You had already mentioned the CDF. And then for me, I was saying the challenge that I see when it comes to the committee, which has to be established, based on when you look at the respondent states' positions on amicable settlement, one where it was not recognizing the representatives of the Ogiek who had brought the case. And so I'm posing it as a challenge that will this time, based on the decision, will the respondent state be able to accept the representatives of the Ogiek, particularly where the court says that the Ogiek are free to establish networks. And therefore, I hope it won't pose much of a challenge when, for instance, OPDP goes back and states that they are there to negotiate on behalf of the Ogiek. Because you remember in the decision, during the merits argument, they have been arguing that they recognize the Ogiek Elders Council, whereby the Ogiek Elders Council has actually been disbanded when the other, I think even before the multi-sectoral task force, it had been disbanded. So those are the challenge. I was pointing more to the challenge rather than a question to you.
Okay.
Yeah.
Okay. Thank you very much for your presentation, Advocate. I hope Mr. Ojenjo also took note of the question you asked. So we're going to go to an intervention from the audience, Mr. Nelson Baye, for just 4 minutes before we open up for Q&A. I see the questions. Please keep posting your questions. Nelson, are you here? Yes, okay. So you can make your intervention for 4 minutes.
Good morning. Please, I'm suffering from a very chronic cold, and I'm sure it's going to interfere with my intervention. To save me the embarrassment of feeling embarrassed, I'll request to go by off video. Thank you. I would like to comment I don't know if you can get me.
Yes, we hear you. You can
proceed.
Yes,
it is very unaware at all that the African Court have not made a multitude of decisions that have dealt with indigenous people's rights. However, the Ogiek case has made some groundbreaking pronouncements on the rights of indigenous people. Before I proceed to make any comment, I would like to commence with 3 main questions. The first question, which of course is directed to the panelists, is do they think does the Ogiek decision adequately addresses the plight of the Ogiek people? The second question is, does this decision facilitate or impairs implementation? And my last question is, does this decision provide a trajectory for a region-specific reparation approach for indigenous peoples? I would like to say that if you look at the decision on the merits, for example, the African Court actually, a careful appraisal of the court's decision on the merits in the Ogiek case had revealed 3 pointers to what could be the possible reparation approach in the reparation decision. And some of these pointers are a communal approach, because the court in its merits decision was concerned more with the social and the collective dimension of the Ogiek community. So in that light, it already envisioned a communal approach to dealing with the plight of the indigenous people. And also, it was also concerned with preserving the indigenous traditions and customs and ethnic cosmovision of the Ogiek people, which means it also speculated a cultural approach. And then lastly, in its decision, the court on the merits, it emphasized that the state provide remedy and report within 6 months measures that they have adopted to remedy the violations, which also implied that in the reparation decision, the court envisaged a prescriptive model. Now, the question I want to ask myself is that in the merits decision as well, the court reiterates that the discriminatory treatment against the Ogiek community has a long-standing colonial history that prevented them from benefiting from the rights and privilege they deserve. Now, the question is, in the reparation judgment itself, these envisaged reparation approaches reflected in the reparation decision? I would say that all the measures envisaged in the merits decision were reflected in the reparation order. However, two of approaches were either passively addressed. I think the court was passive with respect to the intertemporal and the intergenerational character of the Ogiek suffering, since they themselves recognize that it's rooted in colonial history. And then another issue is that the court also had expressed in its merits judgment to be a little bit dissuasive when it comes to providing reparation measures. But if you look at the reparation decision, you realize that the decision lacked specificity. What I mean by specificity, I mean linguistic and content specificity. So what are some of the difficulties and challenges that we could recognize in the reparation decision? Is that we had a lot of genericity and ambiguity of the reparation decision. There was lack of linguistic specificity, like I said. There was lack of responsible state agent specificity. And also there was lack of specificity or detailed explanation how they arrived at their monetary compensation for moral damages. And also in the reparation decision, we could also realize a lot of preponderance of state centrism in the decision. I think these challenges are some of the challenges, like I raised here, is going to actually impair implementation of the court's decision. And the question now is, what is the way forward? What is the way forward if we must ensure a successful implementation of its decision? I think I have one major recommendation, which I think is that the court should try to encourage greater specificity in its decision, because this is going to distort the power asymmetry that exists between the beneficiary and the compensator. And I would also want to say that in future cases, the court should be a little bit more detailed. We understand the difficulties involved in accessing moral damages, but we have the Northern Territory case in Australia, where the High Court of Australia actually have acknowledged that assessment of compensation for moral or cultural loss is a difficult task, which requires a lot of intuition and equitable consideration, no doubt. But the court went ahead to give us a very interesting criteria for assessment of cultural damages, which was very detailed. So it would be very good thing for the court to, in subsequent decisions, render its reparation order much more detailed and explicit. I think in summary, that is all what I can say concerning the Ogiek decision. Thank you.
Thank you very much, Nelson, for that succinct intervention. Thank you. So now we're going to go to the Q&A session. There are a few questions here from the question box that I'm going to read out. The first three, so I think let's do this. I'm going to read out the questions and just say who the ones that have been addressed to people, I'll mention that. And then the others, we can then go over the speakers, say 3 minutes each. We were supposed to have 2 minutes of recap, but I think instead of having the Q&A and then recap, when you respond to the questions, then you go on with your recap. I hope that works. So say 3 minutes for responding to question, an extra 1 minute to recap, since we're already out of time. I hope that works for everyone involved. The first set of questions go to Dr. Mwiza and Nkhata. It says, what is the right of immigrants and indigenous people, and how can they claim this right? The next one.
I sent a note on the chat box indicating that I will be leaving in about 5 or 7 minutes. So just for you to bear in mind. Thank you. I have another meeting at 2 East African time.
Okay, so let me just see if there are any questions directed to you. I'll read your questions first since you have to leave. By Samuel Ndazi says the question is directed to you, but I can't seem to find the question. Implementation of decisions of the African Commission and African courts have proved problematic on the continent as respondent states have demonstrated a lack of political will to implement decisions against them. What role and strategy, if any, does the African Commission as applicants before the African courts have in ensuring full compliance and implementation of its decisions, especially in this one against the Ogiek case? I don't know if you got that question, but that's the question directed to you, Commissioner. So you can go first and then I'll come back and ask the other ones. Thank you.
Great. Thank you very much. Sorry about that. I have another meeting at 2, that's why I'm rushing. This is a very excellent question. I think there are 2 parts to it. The first part is obviously the point about the challenge of implementation. And it's worth mentioning that Samuel in his question made reference to both the judgment of the court and the decision of the commission, that this challenge is applicable across the board, that, you know, it's not the case that in our, you know, legal discourse, it's not necessarily the case that because the commission's decision is not of the same status, legally speaking, as a binding legal judgment with that of the court, and therefore, you know, there is a higher possibility of implementation for that of the court. I think it's worth mentioning that no country, no member state, as far as I know, is not implementing the decision of the commission on the ground that it's not legally binding. Okay, no member state raised that issue. So the issues of implementation are the same for both the commission and that of the court. And of course, some of the assumption questions that I raised earlier on also come out from this one. But the second aspect of the question, I think from Samuel, is what strategies have the commission in terms of following up implementation? I think I would answer that in 2 ways. One is to say the common problem of implementation has to do with the nature of the legal system in which we operate. And the nature of that legal system in which we operate is one that assigns a certain responsibility, division of responsibility, as you know, between the judicial bodies, the human rights bodies of the African Union, and those that are interested with the responsibility of following up the implementation of those decisions. Arguably, it is in the hands of the political or policy-making bodies of the African Union, such as the Executive Council of the African Union and the Assembly of the African Union, that the responsibility of enforcing the decisions of the Commission and the court lies, because these are the bodies that have been assigned specific responsibilities in that respect. And there is a possibility for doing that within the framework of, for example, the Constitutive Act of the African Union, which makes a distinction through the rules of procedure of the Assembly between various kinds of decisions, which have certain consequences in terms of their implementation by member states. So that is one avenue. I think the extent to which we, the human rights bodies of the African Union, are able to leverage that is something that has become a challenge that we have recognized. And there are various efforts that are currently underway in order to get that. The other aspect of, I think, this is the legal avenue. The other aspect for me is really mostly using the existing mandate of the African Commission on Human and People's Rights as it relates to its promotion mandate, and using that promotion mandate for the African Commission, such as, for example, in the context of reviewing state reports, to have a follow-up when it is undertaking promotion mission, to actually ask specific question of where things stand. And also, indeed, by way of statement, press statement that the Commission issues, as we did following the handing down of the judgment on reparations by the court. We issued a statement which is meant to be an instrument also for following up implementation. The other aspect is really for us, institutions like ours, whether it's the court or the commission, I think a lot depends on also the mobilization of public opinion. This is another area. So engagements like this one that we are having today, and other ways of engaging, whether it is through writing opinion editorials for newspapers or through advocacy activities, we need to mobilize public opinion around the follow-up and implementation of the judgment. And these are the various avenues and ways through which I think implementation can be followed up, including, for example, working with national actors such as national human rights institutions, civil society organizations, the representatives of the Ogiek themselves. And of course, I think most importantly, to gauge as much as possible the hearing of the relevant authorities in Kenya, because that is critical, whether it is the Attorney General or other relevant institutions, through whose cooperation the chances for implementation would increase. So that is really my feedback for this specific question from Samuel. I would like to thank you all for your kind attention and look forward to further engagements. As Prof. Franz mentioned, we need to also discuss some interesting decisions that have been handed down by the African Commission as well. Thank you and have a good afternoon.
Thank you very much, Commissioner. Enjoy the rest of your afternoon.
Thank you.
So for the questions addressed to the court, which can be responded to by either Dr. Nkhata or Dr. Teferra, I'm just going to read them. So in the event that the respondent state fails to comply, regardless of the compliance hearing, what remedy is further available for the people? That's one. Another, is there a particular definition that the courts ascribe to words such as aborigine or indigenous? How does natural resource dependence inform indigeneity? Do you think there should be any additional procedures which could be imposed on the state parties to guarantee an effective implementation of the Commission's resolutions or recommendations before the step of referral to the courts? Okay, I think that should have actually applied to the Commission. What balance can be struck to ensure respondent states in referral of cases retain confidence in courts as an independent arbiter? So the question is really asking that, given how the courts references the jurisprudence of the Commission in its findings or in its citation, how does this not affect states' understanding of the court as an independent arbiter, and how can the courts mitigate that? And then the other questions, when you respond, I would then ask to Advocate Tom and Mr. Ojenjo So over to you, Dr. Nkhata and Dr. Teferra. You each have 4 minutes. So you respond to the questions and do your recap as well. Thank you.
Perhaps Dr. Teferra can go first again, since he presented first.
Okay, Dr. Teferra, 4 minutes, please.
Thank you. I will be brief. So I think I can respond to 2 questions. The first one is a question relating to definition of aborigines or indigenous population. The court did not use the notion of aboriginity or people who are aborigine. We used indigeneity or indigenous population. So as I mentioned in my presentation, the court acknowledged the fact that there is no definition in the charter concerning indigenous population. But nevertheless, it took inspiration from the work of the Commission as well as the United Nations Special Rapporteur on the rights of minorities, and identified some key criteria to define or maybe to identify who indigenous population are. In my presentation, I mentioned, for example, the existence of cultural distinctiveness, the history, if there is a history of subjugation, if they have priority in time in terms of occupying the area in which they live, and self-identification. These are some of the factors that the court took into account to conclude that the Ogiek people were indigenous population. The court preferred to use population instead of peoples when it came to indigenous population. So that is the response I have for the first question. Yes, in relation to the definition, there was also the aspect of dependence on natural resources. Of course, as I said, when we talk about the first criterion, the presence of priority in time and occupying and using a particular specific territory and cultural distinctiveness, they are also related to natural resources, dependence on natural resources. For the Ogiek communities, they were hunter-gatherer communities. They used to, or they are still using honey for their survival, so and so on. So the court took into consideration their dependency on the Mao forest. The second question was in relation to the issue of citing the jurisprudence of the Commission, whether this wouldn't affect the position of the court vis-a-vis the respondent states. Maybe they might consider it as partial. Yes, in fact, the court faced this difficulty because, as I indicated, usually the court makes reference to the jurisprudence of the Commission for the obvious fact that the Commission was in existence for many decades, and it has a much more developed jurisprudence. But in the Ogiek case, the court was aware of this fact that a direct citation of the jurisprudence of the Commission might give the wrong impression to the member state, to the respondent state, that it's favoring the applicant. So it tried its best to avoid citing the jurisprudence of the Commission in the Ogiek case. I think these are the questions which I could respond to. Overall, I would like to say that thank you again for inviting us. It was a very brief time, even if the Ogiek judgment was so big, it raised so many complex issues, and we are not able to cover everything. And hopefully we'll have another opportunity to discuss the judgment at length. Thank you very much.
Thank you. Thank you very much for coming on today, and thank you for your presentation as well. Dr. Nkhata, over to you.
Thank you. Let me start off where my colleague stopped in terms of the court citing decisions of the commission. I think what we ought to realize that the commission of its own existence does have the capacity to generate decisions of precedential value. Now, in this case, the balance was, of course, about what impression would it give to the parties, because essentially one of the parties to the litigation was the commission itself. But if you look at the instances in which the court eventually cites the decisions of the commission, it is essentially to confirm what is essentially, what is in essence a position already established in international law. So it is positions adopted by the commission which correspond to settled positions in international law. So I think, yes, there is a potential challenge on the face of it, which can lend itself to interpretations of maybe an imbalance as between the parties. But so far as these positions to which the court has referred to stand for settled positions in international law, my take is that there isn't really too much of a problem there. It's also at the deeper level, a situation that comes about because of the configuration of the system of the African human rights system, which permits the commission to commence cases before the court. I think there's a question about demarcation and delineation of land I think in and around the Mau, and whether this would be alive to traditional boundaries. If you look at the order that the court made on reparations, the court emphasizes the importance of consultation. So the delineation of boundaries will not be done by the government of Kenya acting solo. It must be done by the government acting together with representatives of the Ogiek, fully consulting. So the hope is that in this process, traditional boundaries will be taken care of. And relatedly, there was a concern which was raised by Commissioner Nyanduka about existing interest by other entities and other persons within the Mau. I think the challenge that the court was dealing with, if I could say so, is the practical realization, pragmatism. There are other settlers within this area. How does the court then resolve the interests of those people? Some of them that maybe obtained these interests in a process that seemingly had some legality. How exactly should that be resolved? Which is why the responsibility on the respondent state has been said to enter into negotiations with them to see if they could continue with occupation on certain terms, or if not, to identify alternative lands of equal value. On compliance and implementation, I think in part I will echo the concerns that were stated by Commissioner Derso, in the sense that there is a framework within the African human rights system for the enforcement and implementation of these decisions. The court, after it delivers its decision, barring these innovations that have come about in relation to compliance hearings, if I would call them that, reports to the policy organs of the African Union. And strictly speaking, enforcement follows processes that are undertaken on that arm. So it's not as if the court will run with the ball all the way to the other side. There will be other agencies that have to intervene in order to ensure full compliance with this decision. Overall, I would say, if you look at the decision of the court in the Ogiek case, both at the reparations stage and at the merit stage, but particularly at the reparations, now, both decisions are groundbreaking. I think the court carved out new terrain, particularly in relation to indigenous people's rights in Africa. If you look at the reparations judgment specifically, you note that it takes full advantage of the ambit created by Article 27 of the protocol in terms of carving out reliefs that actually speak to the violations that have been alleged and proved by a particular litigant. So, well, I think these are decisions to be celebrated. We only hope that they will be fully implemented and that the litigants will enjoy the fruits of their litigation. Thank you.
Thank you very much, Dr. Nkhata. Thank you for your time and your presentation. We really appreciate it. So I'm just going to read the last set of questions for Advocates Nyaduga and Mr. Ogiek from CEMIRIDE. For Advocate Tom Nyaduga, the questions are: what would the issues have been different if the matter had been premised on unlawful eviction with or without the question of indigeneity? What does recognition of being indigenous mean? Are there Africans who are not indigenous to some parts of Africa? How will the individual Ogiek people exercise their right to property within the context of the land demarcated for the Ogiek as a people group? And why did the court distinguish between population and people? For CEMIRIDE, the question is: what is the role of CSOs such as CEMIRIDE in assisting the court in the follow-up and implementation of the reparation orders in the Ogiek case? What are some of the advocacy work that you have done surrounding the rights of indigenous people in the economic, social, and cultural rights space in terms of accessibility, availability, quality of public service to indigenous people? I'll say for Mr. Ogiek, please focus on the role of CSOs in assisting the court for follow-up and implementation, since that is the focus of our discussion. Please keep your intervention to 4 minutes. You respond to the questions and give your final recap, so we can then close with the concluding remarks. Thank you very much. Over to you, Advocate Nyaduga.
Thank you very much, Henrietta. I think it's important to state here at the very outset that, and I did state it, and it was also mentioned by my colleagues, that understanding issues around indigenous people, indigenous populations, one has to look at, in the context of Africa, a seminal report that was produced by the Commission in 2003. And this is where the emphasis of their way of life, culture, reliance, their livelihood being more based on land, rather than the mainstream where people, other African people have joined other forms of lives. And this is where the issue about Ogiek looking at the Mau forest as the ancestral land, where there's even a phrase where they say that is their temple, it is their playground, it's their everything that all of us do in other fields, you find them in those areas. And it applies to many other African communities that have their lives very much attached to the land. So it's a very broad topic that in order to understand it, one has to really go through the best literature in the African context is the report of the Working Group on Indigenous Peoples in Africa, which was adopted by the African Commission. So it would give you that context to understand why is it that while they are equally as Black as I am, but they are considered to be a different, they should be looked at as a set of Africans who have these special characteristics and therefore special protections, particularly when they are dispossessed of their land, because what happens in most of these lands where they live, and it applies across the continent with the various types of groups of people who identify themselves as indigenous people. And again, here, the concept of self-identification. It's not for somebody else to identify them, but it is they themselves who identify themselves as indigenous people has to be taken into account. So whether the decision would have been different without indigeneity, or rather in terms of the unlawfulness of such a decision, it goes again to the question of when you are determining the rights under Article 14, or you look at, for instance, the decision, the SERAC decision in Nigeria, where the Ogoni people were affected. The issue around there was not indigeneity, it was more the violations around the land that they occupied and the illegal exploitation of resources by the Royal Shell Dutch Company in collusion or while working together with the Nigerian National Petroleum Company. So really, the interpretation always looks at the content of the article that is being alleged violated, and you go back to start by looking at what does the African Charter provision require, and in determination of such fact, then obviously looking at the facts and the evidence, a decision will be made. So indigeneity has come in because of the particular group of people, the Ogiek, who self-identify as such, and therefore the decision would probably follow what has been said. The distinction between people and population, really, I don't see much in that one, except maybe the court decided to use populations. It's a group of people, and indigenous people is a group of particularly minority groups in many of our countries. So really, the distinction for me is semantic, not very much a legal issue. Thank you. And maybe to conclude, let me also say that I'm very happy and glad to have taken part in this debate, and it's very useful to enable our people to understand issues around the decisions that have been adopted by the court and similarly by the African Commission on these issues. Thank you very much.
Thank you very much, advocates. Thank you for coming through. We appreciate it a lot. Mr. Ohenjo. Mr. Ohenjo from CEMIRIDE, just a very quick response to the role of CSOs in following up on decisions and ensuring implementation of remedial orders. Case in point, the Ogiek case.
Thank you again. I think mine would be, again, very brief to the question, the role of CSOs in supporting the African Commission. Conversations have been ongoing, and recently with Witness, we did a report on the impact of non-implementation of the Enroy's case, and we've sought to bring on board the African Commission, the African Court, in having conversations around just thinking through what the challenges are in terms of ensuring that we are able to chart a way forward in terms of implementing these decisions. We have the Enroy's decision, we have the Ogiek decision on marriage, we have the reparation judgment right now on us. So I think CSOs, for that matter, need to take some position in supporting both states and non-state actors through various strategies, research, advocacy, and stuff like that, to just bring people around the round table and see if there's a possibility of charting the way forward. And I'm saying this with the realization that political landscapes are different in every situation. Kenya is just having a new government. We do not know how it's going to pan out as the new government evolves politically, especially because the current president had in his office an office that was deliberately dedicated to issues for minorities and indigenous peoples and marginalized communities. So we are hoping that there'll be a much bigger space for civil society working with and for indigenous peoples and the indigenous peoples themselves to be able to engage more productively with government going forward. So once again, thank you for the question on what CEMIRIDE is doing to enable, better public service. I think that is something that we can respond to directly. If the person who was asking the question can get in touch with us directly, we are happy to engage on that. But going forward, we are happy to be part of this conversation, and we are happy to be part of any conversation that will ensure the implementation of these decisions. Again, just to pick up a line from the previous speaker, for the benefit of the communities. We want to see this moving from paper to practice. where we can be able to then see livelihoods of people, because the reason why these cases have gone to court to this level is primarily because we want to see the betterment of livelihoods. The protections that are being sought not for the sake of protection, but for the sake of ensuring that the dignity of the people in question is ensured, that they're able to live a life, that is progressive, a life that is devoid of poverty, is devoid of violations. So that is the main objective. So we would want to see the decisions implemented, and we would want to see a turnaround of lives of the people from the communities, indigenous peoples across the continent. Thank you very much.
Thank you very much, Mr. Ohenjo. Thank you. We appreciate what CEMIRIDE is doing, and thank you for your time and your presentation on this webinar series. Thank you very much. So now we're going to speak to Mr. Folusho Adegalu, the Associate Manager of the Litigation and Implementation Unit of the Center, which is the unit that actually organizes this webinar. So Mr. Folusho, over to you to give us a quick closing remarks. Can I put you on the clock for 2 minutes? You have the floor.
Okay, thank you very much, Aretha. I will try my best to stay within the 2 minutes. I think it's been a very interesting conversation, and I will not really belabor the issue by going into the things that have been said and some of the emerging trends that I think we can all pick from what we need to do as human rights stakeholders on the continent to facilitate the protection of the rights of indigenous people in Africa. I think we will all continue the conversation either jointly or, like Mr. Ohenjo said, on bilateral basis. But also just to tell our participant that we also have some good news for you. We will be sharing a very comprehensive report of this webinar on the Center's website in the next few days. And there you can catch all of the key points and everything that have been said and things that we need to do going forward. And also Dr. Teferra has also indicated to us that even though he was unable to share his slide, he will send to us. And please, if you are interested in the slide, you can reach out to us and we are happy to share with all of our participants. Within the time frame that has been given to me, I would like to express my appreciation and thank all of our participants who have stayed with us this long for attending this series of the case discussion. And I would also like to say a big thank you to all of our panelists who have given us very thought-provoking conversation for today: Commissioner Deso, Dr. Teferra, Dr. Nkhata, Mr. Ohenjo, Advocate Yanduga, and of course, Nelson for his intervention. We really appreciate you, and we are sure that we can always count on you and come back to you as we continue with the series of case discussion. Now, yes, this is an event organized by the Litigation and Implementation Unit, but this is also something that has been made possible through the effort of everyone at the center. And I would like to thank the director of the center, Professor Frans Fiyun, who has been our backbone for the case series discussion. And I would also like to thank all of my colleagues in the Litigation and Implementation Unit, including our interns that have really played key roles to ensure that we see the success of this event. And of course, a big thank you to Henrietta for the fantastic job in moderating this session. I would also want to thank the people that really made it possible for us in terms of practicality. Now, we've been speaking about practical issues around implementation. So of course, our communication unit at the Center for Human Rights really made it possible for all of us across the globe and from different timelines to have this conversation. So a big thank you to everyone in that unit, Andile, Mati, Tatenda, Tiruna, Simpiwe, and the entire comms unit. I would wrap up by just maybe emphasizing on some of the remarks of Professor Frans Fiyun and Commissioner Deso that this series of case discussion, like we have heard from them, we are focusing on the 3 human rights bodies. And the first 2 editions have really focused on decisions from the African Court, but efforts are in place and we will surely have more interesting discussions as it relates to the decisions of other African human rights body, which is the African Commission and African Children's Committee. So please stay with us as we continue this series of discussion and watch out for this space. Thank you, Aretha.
Thank you, Felucia. Thank you for that. You've said all the things already, so no need repeating them. So thank you, everyone. We'll see you at the next webinar. It was nice having this conversation with you all today, and see you soon. Thank you. Bye, everyone.